Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law. And today's guests include Kristin Walker, the professor of practice and faculty director of externships at Syracuse University College of Law, and also Veronica Finkelstein, associate professor of law at Wilmington University School of Law. Welcome to you both.
Thanks for having us.
Oh, well, very happy to have you. Kristin is a first-timer on the podcast, but I know this is your second time. And today I'm excited that we'll be talking about your new book, Case Closed, A Practical Guide to Mastering Pretrial Advocacy. So first, I wonder if you can share with me the litigation experience both of you have and what prompted you to think there should be a book like this in the marketplace.
I'm happy to go first. So I've had a pretty varied practice. I was in private practice. I did mostly commercial law, specifically construction law, but I did a little bit of everything. I was at a large firm and a boutique firm, so I did employment work. I was actually an ERISA person. I did employee benefits before I even was out in practice, so I dabbled in that a little bit. And then I spent most of my career as an assistant United States attorney in the civil division, so doing a variety of different types of cases, immigration, court cases, car accidents, slip and falls, medical malpractice, civil rights cases, and affirmative cases like healthcare fraud and procurement fraud. I also was very lucky to be allowed to do criminal child exploitation cases. So I really got a very, very varied experience in private practice. And that was one of my favorite things about being a litigator, was getting to do something different and learning something different in every case.
Outstanding. Kristin, what's your background?
I'm Patricia. So I started off doing corporate work, actually M&A work first when I was first out of law school, and then transitioned into litigation world and did some insurance defense for several years, and then was recruited over to do plaintiff's work. And so I have seen both sides of the table, which has helped me in continued practice, but also in teaching students about pretrial advocacy.
So both of your law schools have strong advocacy programs and reputations. How did you find each other and decide that this was a project you wanted to embark on?
This is a good story. You wouldn't know it just by looking, but we have a lot in common. We are both horse girls from New Jersey. Can you believe it? And we are from the same part of New Jersey, which is wild. So we have a mutual friend in common, another professor at Syracuse who is absolutely wonderful, Todd Berger. I'll toss his name out there. He's a great guy. And so we know him in contact and he connected us. But then once we connected, we have everything in common in terms of our practice backgrounds and wanting to bring that to the classroom, in terms of our goals for students, in terms of where we grew up, and in terms of our love of pie, because every time Kristin is back in town in New Jersey, we have to get pie together at this great place. I'll shout it out in Moorestown called the Pie Lady, which also has a legal connection because she is a lawyer who decided there wasn't good enough pie in Moorestown, New Jersey. So she decided to open up a restaurant and she makes like a dozen different types of pies every day. And then there's a regular menu. Much like Kristin and I decided there weren't good enough materials for the kinds of classes we wanted to teach, but slightly less delicious, our idea.
So you made your own pie in a pretrial book.
That's what we did.
So, Case Closed, A Practical Guide to Mastering Pretrial Advocacy. So why don't we start by talking about this book?
You want to go first, Kristin?
That sounds great. Yeah. So we came across the idea for this book because there needed to be a comprehensive, malleable, application-based workbook to accompany really any advocacy textbook that's already out there on the market. But also this can branch into other foundational course material as well. And it really gives professors an opportunity to choose different skills that students can work on as they are discussing the concepts and theories with regard to pretrial advocacy. It's a great book. It's setting, I think, professors up for some good practice material for students in advance of changes to the bar exam that are forthcoming, and can, really help students understand how to use the skills and concepts that they're learning in practice.
I can add to that. So for many, many years, I taught a practical pretrial advocacy class, which students would come to me and say, I took civil procedure. I learned it. I did well. I know all the rules, but I don't know what I am supposed to do with them. First day on my internship, somebody asked me to do something and the word sounded familiar. I knew depositions existed. I even knew which rule it was, but I didn't know what it was or what I was supposed to do to prepare for one. And so that prompted me to start teaching teaching a intensive pretrial advocacy class that essentially lets students be on teams, represent clients, and litigate a case from the moment the client comes to you and says, I have a problem, I could use help, all the way through the final pretrial conference. And it was a great course that students really loved, but it was always a struggle because I was putting the materials together based on real cases that I had litigated. And while that's sort of interesting in a way and exposes them to different types of cases, it wasn't as effective as having a really thorough book that had all of the exercises and all of the materials that someone had sat down and thought it out and said, how can I make sure that the students who are on the plaintiff side are getting the same experience as the students on the defense side, and really make sure to work in all of the more sophisticated skills that a student might need, taking a corporate designee deposition, dealing with experts. And so that's one of the motivations to sit down and write this book, is to create the kind of materials that you would need for a class like that, but also to create the kind of supplement that you could add on to any class. I teach Civ Pro. I don't want the students to have to wait until their second or third year to learn the practical skills. Maybe it's not a pretrial advocacy class where I would have them every single week doing an exercise or practicing a skill, but it'd be nice to sprinkle them in as formative assessments along the way and to ground the material. Kristin had a great idea of using this in a tort class because our book happens to have a tort file at the heart of it. It's a car accident case, much like the ones that I litigated for much of my career. It'd be great in a torts class just to break up the flow of students reading cases and to let them illustrate that they understand the concepts, not in the setting of an exam, but in the setting of doing a realistic skill exercise. And that's really what the NextGen Bar is doing. So the time really seemed ripe for a book like this. And like many good books, they come out of a need that's recognized by the people who are teaching classes. And so this is exactly the kind of book I wanted for the classes that I was teaching. And so luckily I had a great partner who felt the same way, and we were able to sit down and write it together.
Well, congratulations again on its publication. I did not teach advocacy, but I know that people often relied on NITA case files and that kind of thing. How is this different from that? And in addition to a Civ Pro or a torts professor, how might you recommend that faculty consider using the book?
Why don't I take the first part, how this differs from a NITA case file, because I'm a NITA person too, so that's a good question for me. And I'll let Kristin speak a little bit about the teacher's manual and the supplemental material and some of the differences in how you might use this in those classes versus in an exclusively advocacy class. So like I said, I'm a NITA person, strong believer, teach lots of NITA classes all across the country and outside the country. I also have written NITA case files. NITA case files are a bit different because they are aimed at lawyers. So that's a bit of a difference. We wanted to aim our case file at somebody who's never litigated a case before, not someone who's coming in to polish existing skills, which is a great thing to do, but somebody who is learning those skills for the first time. So that's one difference. The other thing that we wanted to do is NITA programs and NITA case files, in order to support the programs, tend to be very streamlined because you're coming in for a 2-day deposition program or you're coming in for a 4-day trial program. So you're not learning the information as you litigate the way you would in practice. You're getting it all at once. Here's a case file. Here's all the material. So you can prep, come in and do this program. And that's great for a NITA program. That's exactly what you want. But that's not how litigation works in practice. That's not how pretrial works. You don't show up and somebody hands you a bound copy of this is the case, go ahead and get ready for a pretrial conference. It doesn't work that way.
If only it did, right?
If only it did, but then what would they need us litigators for? It's more fun, right? And so our case file is our book is sort of metered into individual skills exercises. You can pick and choose, have students do some of them and not others. You can talk about some and have students perform others. You can have students perform some individually and some in pairs or groups. You're really very flexible. But then after each exercise is done, students learn a little more information. They get a little bit more about the case. And so it more realistically is designed to mimic the litigation process in a civil case than a NITA case file, which is terrific when you want to come in and just work on a specific discrete set of skills and you have a limited time frame. So So that's one difference from a NITA case file, though I will say that you can take our book and the materials, you could use it for a trial advocacy class if you wanted. There's no reason you couldn't. You could use it for a NITA program if you wanted, but it's designed to mimic the process, whereas NITA case files do not mimic the process. They're designed to let you exercise and practice a particular discrete set of skills. I'm going to kick it to Kristin to talk about the teacher's manual and how you might use it. And I think that'll also highlight some of the differences between a NITA case file and this book as well.
Thanks, Veronica. Yeah, and so I do teach a pretrial advocacy course and have been using these skill-based exercises throughout the course, even prior to this book, which gave me a lot of material to work with and student feedback over the last few years to sort of incorporate into the book. And so it really does take you from the time of intake of a case all the way up through settlement in very piecemeal fashion. So it covers skills, as we mentioned, which are applicable to the modified bar exam, but, client interviewing, discovery, depositions, very practical based exercises, settlements. There's some ethical discussions in there as well. But this can also be used outside of the advocacy context. So we have particular courses, I know, in our College of Law that focus on depositions in particular, or perhaps client counseling in particular. And so this supplement can be a go-to for any other very niche courses that are just focusing and honing in on particular skills themselves. So it's very malleable in that sense. I also find it to be very helpful for adjuncts coming in to teach for the first time, particularly in pretrial advocacy. As Veronica mentioned, there's a full teacher's manual that accompanies the exercise and is really a walkthrough, a hand-holding through the process, so that even if you haven't taught a pretrial course before, this is a great place to start. And it really does sort of walk you through the process. There's also rubrics that are included for each exercise. And so there's sort of guided pointers in terms of what to look for, how to properly assess students. So it's very, very comprehensive in terms of covering some of these skills.
And the one thing that I'll add that we don't have in NITA case files that we did include in this book, because we really wanted this to be useful for faculty members and teachers, but also for students, is before each exercise is a nuts and bolts explainer. Here's the rule of civil procedure that's in play here. Here's why we have this rule. Here's how it works. So that even if you have a student who isn't in a class that is utilizing the exercises, it's basically a horn book on how the rules of civil procedure actually apply in practice. It's the kind of thing you might want to have at your desk your first year in practice, where, someone has said, like, draft these discovery requests and send them out. And then you're sitting there to yourself going, what's going to happen next in this case? Well, you can go to that section of the book, flip to the next chapter, and there is an explainer of what's going to happen next, what you should be doing when you get the discovery responses back. You should be populating your proof chart. You should be keeping track of how you're going to ultimately prove up your case and start thinking about who you might want to depose or what third-party discovery you might want. So that also is a difference between this book and a NITA case file. A NITA case file assumes you know the law, you know the rules, we're just here to work on the skills. And this is also focused on skills, certainly, but it is a way of reinforcing and teaching the substantive civil procedure rules along the way. But instead of just teaching them in the abstract, hey, here's Rule 8, take a look at what it says. You've got to apply Rule 8. You've got to draft a pleading. You've got to actually use it. And so it's pretty reinforcing in that way, but it's also a good reminder. So that's another difference that I just wanted to highlight.
So we talked about how it's different from a NITA case file. Are there other books on the market like this that have a case like this that takes the students through a semester of pretrial work on a single case? And if so, how does this one?
I haven't seen one like ours. There are certainly some books that lead a class through the stages, talking about the stages and maybe give examples from a hypothetical case, but I really don't know of anyone on the market, and I certainly couldn't find one when I was looking for one that does what ours does. Our teacher's manual has, 50 pages of discovery that is not in this book, that the students have to draft good discovery requests or else they're not going to get. And that shapes how they litigate going forward after they get this information. It puts them in the position of dealing with a corporate designee and drafting a 30B6 deposition notice. And it's got a lot built in that I think your average pretrial advocacy book doesn't have. So, at least I can't speak to everything that is on the market, but I haven't seen anything quite like this. this. It is almost a hybrid of a case file and a, hornbook or nutshell that sort of gives the top level explanation, and an actual sort of supplemental textbook that gives assignments to the students or suggests assignments that the students might do with that information. And in that sense, I think it's bringing together some things that are currently on the market, but that maybe don't exist together. And the other thing that I'll say about it that we tried to fill a gap in the market when we were drafting it is we didn't want to make it too tied to anybody's particular textbook. Like, this is the supplement that goes along with this Civ Pro book, or like, this is the supplement that goes along with this pretrial advocacy book. We just wanted this to stand alone. So you can use this no matter what you are teaching with. And that's another thing that I noticed when I was looking for materials to teach a class like pretrial advocacy. A lot of them were keyed up or linked to a particular textbook, and that might not be the one that I was using. So that's another way to distinguish our book a bit.
It's interesting to hear you describe how the students would work through it. So conceivably, students would miss things in this case file. If you really went along the lines of, they had to ask the right questions, if you will, in a deposition or in discovery. So there could be alternative outcomes, I guess.
There could. So I'm a pretty nice person. So I always played by the rules when I taught this class and when I'm using this book now, that if you don't ask good questions, you'll be at a deficit, but I'm going to solve your deficit eventually. So you won't remain at a deficit forever. So if you didn't ask good discovery questions, you're not going to get the same things that other students will get right now, but you may have to do a self-evaluation of how you could have done better. I'm pretty nice, but you're absolutely right. You could run it like real litigation where, different students are operating at different levels depending on how they've been performing all along. That's absolutely a choice.
That's interesting. And I assume it's adaptable just by jurisdictions.
Yeah, so it's in federal court, so the federal rules of civil procedure apply. It's there under a federal question. It's a Federal Tort Claims Act case. It's a car accident case involving a federal driver. But then you can designate that the state of Wildcat, which is where this is happening, where the accident happened, you can designate that the state of Wildcat is Pennsylvania or Texas or California. And so it gives some nice flexibility to professors as well, who are maybe worried about students using AI to do their assignments or getting the go-bys from the year before. The case file is situated in a fake jurisdiction. That's not going to be super easy for AI to deal with. And you get to designate as the professor from year to year or class to class or semester to semester where that state is located, and that will affect the substantive law. It is a negligence case, so the law is not wildly different from jurisdiction to jurisdiction, but it's a good check on students actually doing their work independently and not just copying a go-by from a prior class or, feeding it into AI. Hey, write a motion to dismiss in the Eastern District of Pennsylvania using these facts. You also can use it as a closed or open universe case file. You can tell the students, here, these are the 10 cases you're allowed to use. That's all the law there is on this for our purposes of our class. Or you can make it an open universe kind of research class where it's up to them to find the law.
I can just add, I think using negligence as the basis kind of keeps it from being too overly complex on the law side. And it really allows students and their professors to really focus on the skills. And I do the same thing in my course as well. So
when we're talking about this skill building and the exercises that you have, how did you keep the NextGen Bar in mind? And how will this help students who use the book with the NextGen Bar?
So I've been thinking about the NextGen Bar nonstop. I have learned to draft multiple choice questions with 6 answer choices and 2 of them are correct. Like nobody's business, I've been thinking about integrated practice sets where it's one set of case facts and you can do multiple things with it, including a skill demonstration. And of course, it's a little hard because we haven't actually seen a group of students take the NextGen Bar, and they've released some sample questions, but we haven't seen a full bar exam yet. And so you're a little bit guessing what are the practical skills that they expect students to have that they might ask them to demonstrate on the NextGen Bar. And that is one of the reasons why I thought we needed this book now, because you can come up with a list of here are the 12 most likely skills they're going to test on. But if your students don't know how to think and act and write like a lawyer, they are going to be very thrown off if you are wrong, if the skill that they're asked to do is slightly different than the one that they have practiced or is applied in a slightly different setting. I think the much better way to prepare students for the NextGen Bar is to essentially make them ready to serve clients. And being ready to serve clients means not just having done this list of 10 skills that we think are really common: draft a complaint, draft an answer, draft discovery request, respond to discovery requests. Those could be the things they're asked to do. But how do you service a client? When a client comes in and says, I'm injured and I need your help, what are the things you need to be thinking about from a strategic point of view to litigate a case like that? That, I think, is the real heart of the difference between the NextGen bar and a more traditional bar exam. Of course, you have to demonstrate the knowledge of the substantive law. You can't help a client if you don't know what damages are recoverable. Absolutely. But there's a difference between writing an essay analyzing what damages are recoverable under a particular statute and writing an email to a client explaining why you understand that they're hurt and they want punitive damages, but that's not the sort of damage you can get against the federal government in a Federal Tort Claims Act case. And the only way to really prepare them is to get them to think like lawyers who represent clients, rather than just adding a list of a dozen additional skills that they need to learn. They really need to sort of be able to mimic actually being a lawyer. So that's my thought process for what it's worth. We'll see if I'm right when we actually have students take the NextGen bar and start getting results back, but that's my thought process. I don't know, Kristin, how you feel about that.
Yeah. So in addition to Veronica, I've been thinking about this as well, as I think many faculty are. And I know there's a lot of work being done to try to assimilate some of these skills-based, exercises and learning into current curriculum to be sure that everyone is preparing students for the NextGen bar. And so I think the exercises in particular just make that easy. This book really makes it easy. Offers exercises involving client counseling, as Veronica mentioned, how to really think through and, problem solve to solution, but also translate that into counseling through these application-based exercises. And I've gotten really positive feedback from my students going through these, skill-based exercises even before the book was published, in terms of how it helps them sort of bridge the gap between law school and the foundational courses they're learning and what they're going to do in practice.
Well, congratulations again on the publication this fall of Case Closed, A Practical Guide to Mastering Pretrial Advocacy. It sounds like a really rich resource for professors teaching a variety of subjects and for the students who are using it. Before we move on, Veronica, this is not your first time on the podcast. You have another Aspen book, Ethical Lawyering, A Guide for the Well-Intentioned. Do you want to just tell us a little bit about that and your co-authors?
Sure. I'm very proud of that book. So that also came out of teaching professional responsibility, which I have taught every way that you can teach it, including standing on my head, it feels like. I've taught it online. I've taught it in person, asynchronous, not asynchronous, live together. I taught it during the pandemic and before, with a case file, experientially, by reading cases, by doing problems. And it just really struck me that there was no good book out there that was the ideal way to teach professional responsibility. And it should be one of the most core classes in law school. And frankly, one of the most interesting, because as lawyers, you love reading those sort of headlines that come down, those cases gone wrong. Can you believe somebody did this? Someone's getting sanctioned for doing this. And that stuff's juicy and fun. So why is PR so boring? And I think the reason why students think it's boring and not important is because they don't see how it will actually apply when they get out and practice. It's a bunch of rules. They memorize them. They take the MPRE exam, they pass it, and then they think, good, I've dealt with that. I don't have to worry about it anymore. And then they are faced with a conundrum or a difficult situation in practice, and they don't know where to turn because they never really learned how the rules were likely to affect the decision making they would have to do. And so, along with my co-authors, we created this book. It stars a series of recent graduates from a law school who are in the kinds of jobs that recent graduates might have. So none of them is a judge. You've got someone who's a district attorney in a city. You've got somebody who's at a small firm, somebody who's an associate at a law firm. And it teaches the rules by putting these characters in realistic situations where the rules might arise. And then it has a series of exercises for professors and students to work through. They can either be something you do in class, they can be something that are assigned afterwards. And then because I'm a big fan of multiple choice, each unit ends with some multiple choice questions so that students feel prepped for the MPRE. So I think think it makes PR fun, and hopefully it, has been making students enjoy PR and see how it applies a little bit more than some of the other more traditional methods.
Outstanding. Well, that is Ethical Lawyering, A Guide for the Well-Intentioned, and I think you're on your second edition. Is that right?
We are. We just finished the second edition. Different colors on the cover. That's how you can tell.
All right. And then now, Case Closed, A Practical Guide to Mastering Pretrial Advocacy, the first edition. So again, congratulations to you both. And I wonder if you could share with me now, as I ask all my guests to conclude with, what your predictions are for the future of legal education in the coming decade. Kristin, maybe we'll start with you. You're at a school that has done online legal education for a long time, has really intensive advocacy programs. It's a pretty innovative school, Syracuse College of Law. Can you share with us how you think legal education might change in the next 10 years?
Yeah, absolutely. So I definitely see in my role as the faculty director of our externship program here a rise of interest both on the practice end of it, but also from our students in terms of being involved in externships or clinics and getting some practical experience as they're going through the law school process. So I definitely see a trend even since the time I was here. And as well, we've started our JDI program several years back that has grown extensively and is really on par with our JDR program in terms of how robust it is for us. So making access to our courses and certainly our professors more readily available to students all over the world, and accommodating different practice professions that they're presently involved in, including our military, has really been great for our College of Law and our students. And I think this book is, it's helpful because it is, again, sort of providing a good bridge for our students in the connection between learning the foundational elements of these concepts and theories in the classroom and translating that into how it comes about in practice, how they'll use it in practice.
I feel like you could ask me this question on any day and I might give you a different answer. But at the moment, it does strike me that one of the things that seems to be a development in legal education and the law practice in general is alternative pathways to practice beyond just the bar exam, either in the form of the NextGen Bar Exam, which is meant to be a little more realistic and client-centered, but also in terms of diploma privilege and the different pathways to diploma privilege that various jurisdictions are investigating or adopting. And it seems to me that there's kind of an interesting tension here. To do these alternative pathways, you certainly have to have students who are more practice ready. That is clearly one of the motivations of the NextGen Bar. Some of the jurisdictions, their alternative pathways require a portfolio of work product that will require students to have exposure to different areas of practice, to have the materials for that portfolio. But then by the same token, if you're not testing on general understanding of substantive knowledge with the bar exam, it does strike me that sort of renews the need in law schools for good core classes on the core subject areas that are going to be encountered by practitioners. So you shouldn't be able to graduate if there's diploma privilege, having only taken electives in bird law and like regulation of cannabis. Like those might be super interesting courses, really useful in certain niche fields, but you shouldn't be able to practice as a lawyer if you don't know what a contract is, or you're completely confused about what the Fourth Amendment does and doesn't require. So it strikes me that we're kind of going to be back to where we are with a need to balance experiential learning, practical skills development with some of those basic core classes again, which maybe does suggest that there is something to the idea of having a set curriculum of some sort and requiring a general base knowledge of all practitioners that they get in law school.
Well, thank you. I have really enjoyed talking with two horse girls from New Jersey, and maybe next time I'm in New Jersey, we can have pie together.
You should come have some pie. It's that good.
Congratulations on Case Closed, A Practical Guide to Mastering Pretrial Advocacy. I appreciate your being with me again, Veronica Finkelstein and Kristin Walker, for the first time. So if you enjoyed listening to these thought leaders in legal education, we have additional episodes with other thought leaders on your favorite podcast channel or the Aspen Leading Edge podcast webpage. Thanks so much.
Thank you.
Thank you.